This is Bloomberg Law with June Grasso from Bloomberg Radio.
On March 12th, my husband Kilmer was abducted and disappeared by the Trump administration.
Kilmer Abrego Garcia was living in Maryland with his wife and 3 children when immigration authorities arrested him and flew him to prison in El Salvador. Under a 2019 court order, Garcia cannot be deported to his native country of El Salvador because he'd likely face gang violence there.
This so-called administration error has destroyed my family's happiness.
The Trump administration admits that it made a mistake, but argues it can no longer do anything about it. On Thursday, a unanimous Supreme Court ordered the administration to take steps to bring Garcia back. My guest is Leon Fresco, a partner at Holland & Knight and the former head of the Office of Immigration Litigation in the Obama administration. Leon, the order here was just 3 paragraphs long. Tell us about it.
At the end of the day, what the Supreme Court is saying is there was an agreed administrative error here. So since there was an error and this person clearly has been now stipulated on all sides as an individual that should not have been removed to El Salvador because he had this order called withholding of removal that prevented his removal to specifically El Salvador, that this person had to be brought back, that injunction that was issued by the district court is correct. But the question is, what does it mean that the government has to, quote unquote, facilitate the return as opposed to effectuate the return? And that's really going to be, I think, a knockdown, drag-out issue that's just going to come right back to the Supreme Court.
So technically, the Supreme Court didn't order his return.
This is what is very complicated about this decision, is that the Supreme Court basically gave a thankless task to the district court judge because it said that, yes, the government needs to act to do what it can to bring back Mr. Abrego Garcia to the United States, but it said within the proper constitutional limits of the court. Here is the exact line. It says, the district court should clarify its directive with due regard for the deference owed to the executive branch in the conduct of foreign affairs. And then it says, for its part, the government should be prepared to share what it can concerning the steps it has taken and the prospect of further steps. So it's trying to align itself with the concurrence of Judge Wilkinson, the conservative judge in the Fourth Circuit, saying there is an ability for the government to facilitate the return of Mr. Abrego Garcia, but what it can't do is issue these sort of global injunctions ordering El Salvador to do anything or ordering the United States government to order El Salvador to do things. So this is going to be very complicated because unlike a normal deportation case where the government has been able to bring people back when there's a dispute about their custody, here the Trump administration is saying this person is in El Salvador, end of story. We cannot order President Bukele to do anything. And so this is going to be protracted litigation, in my view, that's going to go right back up to the Supreme Court, because you're going to have the district judge say, bring him back, and you're going to have the Fourth Circuit say what it said again, and you're going to have the Supreme Court have to deal with, look, is this prison really in the control of the U.S. government, or is it something where it's really in the control of El Salvador and the U.S. government can't do anything about it?
Despite the complexities, this is a unanimous decision by the Supreme Court in an immigration case.
It is a 9-0 decision, and any 9-0 decision in immigration is very, very, very surprising. You even have Justice Alito, who almost never rules against the Department of Justice on immigration. Now it's 9-0 with a concurrence where you have the 3 justices, Sotomayor, Kagan, and Jackson, saying you have to bring this person back. End of story. You've brought people back in the past. Bring this person back. And they're sort of anticipating what's going to happen, which is that this case is coming right back to the Supreme Court. I've actually seen already tweets from the Trump administration saying, what do you want us to do? This person is in El Salvador. they belong to El Salvador, end of story. We can't do anything. We've won this case.
You may be right, because it's already very contentious. In a hearing on Friday, the Trump administration lawyer refused to tell the judge what the government is doing to bring Garcia back or even where he is. Judge Paula Sinise asked, quote, "This is a direct question. Where is he and under whose authority?" And the answer from Justice Department lawyer Drew Ensign was, "We are still internally reviewing the Supreme Court's decision and vetting what we can say to this court." So no answers there.
I mean, I'm sure the district court is going to say this person is in the effective control of the U.S. government, because there's no way that El Salvador would refuse to return this person back to the U.S. if the U.S. insisted. But the question is, by the time this case gets back up to the Supreme Court, is the Supreme Court actually going to take the step of saying that this person is really effectively, for all intents and purposes, in U.S. custody? Or are they going to allow this sort of separation to exist in the legal sphere and say, well, they're in El Salvador, they're an El Salvadoran citizen, and they're under the detention of the El Salvadoran government? What really can you force the U.S. to do in this situation? Do you want them to go to war or something to bring this person back? That's not something a court can do. And so this case is long but over.
I mean, in the past, the government has brought people back who've been wrongly deported to foreign countries.
Yes, this happens dozens of times per year. There's many times not even reported judicial decisions, because what will happen is the appellate courts won't issue a stay in a case, and then by the time the government actually starts briefing the case, they realize the person had been removed, and they say, oh boy, probably we shouldn't have done this, and the person comes back. So that happens all the time. The difference here is twofold. One, you have an administration that for the first time is contesting this, that they even have the legal ability to bring someone back. So you've never had that before. You've always had administrations that are amenable to bringing people back. This is the first one that isn't. But then secondly, this is the first time that you have a foreign national literally in the custody of the country to which they were removed. And so that's a whole new set of facts. If that government had some interest in actually having that person in custody, that would be quite the issue. Now, what makes this even a higher level of complexity is this was literally the exact harm that the person got relief for, which is that they said, if I get deported to El Salvador, I will be persecuted by the government and sent to some terrible confinement facility where I will be tortured and possibly killed. And so this person is literally living the manifestation of the thing that they were given relief for not to happen. So I cannot say how complicated this is.
Now, this decision came 2 days after another immigration decision where the court ruled that the administration can keep using the Alien Enemies Act, a wartime law, to deport alleged Venezuelan gang members, but that the administration has to give the detainees notice and a chance to be heard.
So the Supreme Court said that the government can use the Alien Enemies Act at the moment to try to begin a process of deportation, but that people have a right to challenge in habeas, whether you can actually on the merits use the Alien Enemies Act. So yes, they can begin this process, but can the Alien Enemies Act actually be used? And what I mean by that is usually the Alien Enemies Act is invoked in the time of war, World War I, World War II, etc. This is the first time it's being invoked for the principle that there is a group of people who've committed some sort of informal incursion in the United States for the purposes of destabilizing the country, which is this Venezuelan gang Tren de Aragua. So that's one analysis. Can it be used for an informal gang as opposed to during an actual declared war? They want the lower courts to hear those arguments and flesh out some logic here before it gets to the Supreme Court. That's number one. But then number two is, even if it can, does the person have the right to say, yeah, but I'm not a member of this gang. I'm from Cleveland, for instance. Why are you deporting me to El Salvador or Venezuela or anywhere else? Or even, I'm a Venezuelan hairdresser that's never stepped foot in a gang, And so now there is an established Supreme Court decision that says, yes, in habeas, you get to make this argument.
And also the detainees have to file the habeas in the jurisdiction they're being held in, which is happening already.
So the ACLU went and filed habeases in New York and in the Southern District of Texas, and immediately there were 2 stays of deportation issued, both blocking the removal and both under the grounds that the plaintiffs were likely to succeed in their habeases, saying that the Alien Enemies Act could not be used to accomplish the type of deportation that the government wanted, the normal immigration court removal process. This is going to be a very interesting process that I think will also get to the Supreme Court about, there's sort of 2 layers of briefing. There's one, are you subject to the Alien Enemies Act, as it were, meaning are you actually one of these Tren de Aragua gang members? But there's a second, which is, should this thing even apply? And should you actually just go to immigration court and be able to make any defense that you want and not be subject to this special type of hearing? So there's both kinds of analyses, and the courts may need to do both. And we'll see what ultimately works its way up to the Supreme Court as a result of this.
This administration is certainly keeping the Supreme Court busy. Thanks so much, Leon. That's Leon Fresco of Holland and Knight. Coming up next on the Bloomberg Law Show, are Trump's Supreme Court victories more about procedure than substance? I'm June Grasso, and you're listening to Bloomberg. President Trump is turning to the Supreme Court over and over again as lower court judges rein in his efforts to push the limits of executive power. And the court's conservative majority seems to be accommodating him with narrow wins that allow his administration to move forward with his agenda, deporting alleged Venezuelan gang members, halting teacher grants, and firing federal workers. Is it any wonder that liberal Justice Sonia Sotomayor, who dissented in all these administration wins, recently expressed concerns about the rule of law?
One of the things that's troubling so many right now is many of the standards that are being changed right now were norms that governed officials into what was right and wrong. Once norms are broken, then you're shaking some of the foundation of the rule of law.
Trump has been touting these victories, but a close look shows they're wins based on procedure rather than on the merits, more form over substance. My guest is constitutional law expert David Super, a professor at Georgetown Law. David, if my calculations are correct, the Trump administration has made 10 emergency applications to the Supreme Court in less than 3 months. I'm sure that's a record, but why is the Supreme Court addressing so many of these issues?
Well, the Trump administration is making sweeping changes in our system of government, changing things that have been understood at least since the New Deal and many of them since the founding. So these are important enough issues to merit the Supreme Court's attention when they are enjoined for being unlawful.
So last Friday, the Supreme Court allowed the Education Department to withhold money for teacher training projects in 8 states. It was a 5-4 decision. Chief Justice John Roberts sided with the court's 3 liberals who would have turned Trump down. Do you see why he was with the court's liberals in that particular case?
Well, he didn't write an opinion, and he didn't sign the opinions written by the liberal justices. So my sense is that he simply didn't feel that the administration had made a sufficiently compelling case, and he wasn't entirely persuaded by what the conservative majority wrote in their opinion.
So did the conservative majority basically go off on a procedural point?
Yeah, many of these cases are procedural. The majority is looking with a very powerful magnifying glass at the procedure and in particular about which court something is filed in, and are in 3 of the most significant cases finding that they don't believe it was in the right court. That says nothing about the merits if the cases get refiled in the court that the Supreme Court prefers. So I don't think we can read very much into it other than that this court is hoping against hope that if they give the administration a little more time, that it will come into compliance with the law.
Justice Ketanji Brown Jackson, in a dissent, said it was beyond puzzling that a majority of justices conceive of the government's application as an emergency. I mean, it doesn't appear that there's a real emergency in most of these applications to the court.
No, it doesn't. There's no indication that funding these teacher training programs would do any devastating harm. But everything the administration does these days, it claims, is an emergency, and their basic theme is that they get to define what an emergency is, no matter how absurd that claim is. And for the moment, the Supreme Court is humoring them on this. My sense is that that game will only work for so long.
In probably the most high-profile of these emergency petitions, on Monday, the court allowed Trump to continue deporting Venezuelan migrants to prison in El Salvador under the Alien Enemies Act, granting an emergency request on a 5-4 vote without deciding if he was using that law lawfully.
Yes, they said that case should not have been in the District of Columbia. It should have been in the Southern District of Texas. And the reasons for that are not silly, but not very compelling either. There certainly were plausible reasons to have filed the case where they did, but I think they're hoping that if they make the case start all over again in the Southern District of Texas, that the administration will chalk that up as a win and back off from its absurd policy.
They also didn't address the fact that hundreds of Venezuelan migrants have been shipped to El Salvador already and are in prison there, a harsh prison. And Bloomberg News found that just 7 out of the 238 migrants have been found guilty of serious crimes. I mean, they're sending people there based on tattoos and the kind of clothes they're wearing, and the court just let that go by?
Well, the court said that there wasn't jurisdiction in the District of Columbia, so they haven't said this is okay. They have instead insisted that all the T's be crossed and all the I's be dotted before a court takes action on this. Jurisdiction is one of the fundamental attributes of courts, and they do need to attend to their jurisdiction. On the other hand, past courts have been willing to resolve close questions on jurisdiction in favor of getting justice done. And here, 5 members of the court were not willing to do that.
Again, it was 5-4, but this time Justice Amy Coney Barrett joined the liberal justices. Any accounting for the Chief and Justice Barrett switching positions in these 2 cases?
I think that both cases, the majority's argument was tenuous, and it wasn't enough to persuade the chief in the first instance, and it wasn't enough to persuade Justice Barrett in the second instance. Both are signaling that they are not rubber stamps for the administration, but both of them, I think, are also signaling that they would like to give the administration a chance to come into compliance on its own. How long their patience will last remains to be seen.
Then on Tuesday, in the first mass firing case to reach the court, the justices bolstered Trump's campaign to fire federal workers, blocking a judge's order that required the administration to reinstate employees. So this was 7-2 with Justices Sonia Sotomayor and Ketanji Brown Jackson dissenting. Again, based on procedure?
Yes. The argument was that these cases should have been brought initially through the Merit System's civil service process and resolved there rather than in federal court. If there had been one individual person fired based on a quibble over whether they were taking too much sick leave, absolutely the Merit System's process would be the right place. When it's being done as a matter of policy on a mass basis without any consideration of individual circumstances, an injunction seems more appropriate, but here the court decided to, again, insist on jurisdictional perfection.
Is the majority sort of taking the easy way out in these cases by making it more about procedure than about the merits or the administration's policies?
Oh, yes, very much so. You're not seeing opinions endorsing what the administration has done. That would be very easy for them to write, either as an opinion of the court or as a concurring opinion from Justice Alito or whomever, and you're just not seeing that. You're seeing nitpicking on jurisdiction. So no one is sending the administration signs that what it's doing is okay. And I think if the administration's lawyers are paying the least bit of attention, they will recognize that they're being given time, but absolutely no encouragement on the merits. If the administration's lawyers are any good, they're telling them behind the scenes that you're dodging a bullet here and dodging a bullet there, but that the silence of even the most conservative justices on the merits of your action is quite deafening. And once the plaintiffs follow the instructions of the court as to how to obtain jurisdiction, the court is giving the administration no encouragement that it will get support on the merits.
On Thursday, Trump went to the Supreme Court after the full D.C. Circuit Court of Appeals reinstated two independent agency officials who had been fired by Trump without cause. And the Chief Justice put that D.C. Circuit Court decision on hold, so the fired workers remain fired. Does Roberts' action indicate support for Trump's efforts to remove any limits on his power to hire and fire?
That's not clear. The Chief Justice has previously stayed actions of lower courts and then turned around and voted against the administration on the merits. So at the moment, all we can assume is that this stay is an indication that he thinks that all the justices ought to be able to weigh in, which is sensible enough on an issue of this scale. On the other hand, the question of independent agencies may be a more complicated one in the court because several justices have indicated that they don't like independent agencies or don't believe that their independence is appropriate. So on this one, it certainly is possible that when all is said and done, the administration will succeed in changing constitutional law. I don't like the administration's chances on most of the others.
Now, on Thursday night, the Supreme Court handed the Trump administration a high-profile defeat when a unanimous court ordered the administration to return to the United States a man who had been deported to El Salvador because of an administration error. Where does that decision fit in this puzzle?
Well, I think it suggests that the Supreme Court has its limits, and it's telling the administration that. We've now got two unanimous decisions in the scope of a week regarding sending people overseas. The first one found a procedural fault with the case that had been brought, but said that everybody has to be given notice and a chance to ask for a hearing before they can be sent overseas. And then for this gentleman who was sent overseas without any process at all and contrary to law, they've now unanimously told the administration to get him back. That suggests that the court is trying to give them space, trying to give them leeway, but when it sees serious abuses, it will step in.
And why was it important that this was unanimous?
It's important because this administration has already shown that it's not very concerned about violating court orders. It's violated many lower court orders. And I suspect that the justices were concerned that if there was a split decision from the Supreme Court, the administration would seize on that to refuse to comply as well. During the desegregation era, the Supreme Court worked very hard to achieve unanimity, even if the decisions that they wrote weren't as sweeping as they would have liked, just because there was concern that many people were disregarding the opinion. Similarly, in the Nixon tapes case was unanimous, with the Chief Justice writing the opinion, even though many of the justices would have preferred a stronger opinion. Unanimity was more important.
This has been a fascinating discussion. Thanks so much, David. That's Professor David Super of Georgetown Law. Coming up, Trump's war on big law is bringing in close to $1 billion in free legal services. I'm June Grasso, and you're listening to Bloomberg. President Donald Trump's unprecedented attack on big law is yielding him hundreds of millions of dollars in free legal services, as many of the top Wall Street firms cave and settle with the administration, some even before they've been targeted in an executive order.
We signed with many law firms, the ones that we thought were inappropriate.
Inappropriate seeming to mean their lawyers acted against Trump, his policies, or his allies in some way. These executive orders generally require that security clearances of a firm's lawyers be suspended, that federal contracts be terminated, and that employee access to federal buildings be restricted. While some firms have chosen to settle, others have chosen to fight Trump in court, where judges have already found his executive orders likely unconstitutional. So why does one firm settle while another litigates? Here to tell us is Bloomberg Law reporter Justin Henry.
Justin, how would you describe the firms that are settling?
So the firms that we're seeing settle are primarily concentrated in New York. I think all of them are headquartered or at least originating from New York and have real Wall Street pedigree. They're also much more wealthy, and a lot of that wealth has come from their rainmaker transactional practices, so corporate deals involving mergers and acquisitions and private equity.
And explain why the firms that do transactional work want to settle with Trump.
So my understanding is that they have really sensitive client relationships, clients who are very averse to being in kind of the political limelight. Some of those firms have client relationships that are worth $100 million a year in revenue or more, and those are client relationships that could vanish literally overnight if their lawyers can't represent them in front of government agencies or get the same kind of attention from regulatory agencies to put the deals through. And then that, in a matter of days, could decrease the overall profitability of the firm, which would have a cascading effect on other partners of the firm, making less in profits and then also being vulnerable to poaching by other firms. So you could have a phenomenon that resembles the kind of run on the bank.
So they're even afraid that their partners will abandon them.
Exactly, yeah, and not for any individual lawyer's sort of decision-making on the process. It's really a coordination issue where, they might want to stay with the firm. The clients might want to stay with the firm, but just because of business reasons, not because of political reasons, there's no shortage of other firms looking to scoop up that business. And they can come to them and say, hey, listen, we're not in the negative limelight of the president. Come to us. We still have a good relationship with the administration, or at least we're not in the crosshairs of the Trump administration.
Right. And with these transactional firms that have to deal with the regulatory agencies, it could be a problem if they're in the bad graces of the Trump administration.
Yeah, exactly. I mean, a protracted dispute with the Trump administration can make them seem like kind of a pariah, politically speaking. That makes clients look at them and say, well, we're worried about not getting good treatment from the regulatory agencies that have to approve our massive bet-the-company deals. Those very expensive, very lucrative deals require the goodwill of the executive branch agencies, and that is something that is at risk when you're in a protracted dispute with the Trump administration.
You spoke to Bruce McEwen, who was a former in-house lawyer at Morgan Stanley, and he said law firms, for all their seeming solidity, are very fragile economically.
So law firms really aren't organized like any other type of business, except for other professional services businesses like accounting. What makes law firms different is that their shareholders are internal to the company. And those shareholders, who are the partners, have the ability to go to any firm they want at the drop of a hat. There are no non-compete agreements in the legal field like there are in other professions. So the law firm can't impose any restrictions on one of their lawyers moving to another firm, a competitor firm that's willing to pay them more. And so that's a huge reason why law firms are much more a precarious type of business than other types of businesses.
And the firms that are fighting back, what are they best known for?
Yeah, so these are firms that are very famous for their work in the areas of litigation. And litigation is just a practice area that, is still very sensitive to politics, but already kind of has an adversarial stance by definition. Just a breed of lawyers who are much more willing to take an adversarial stance, whether it's with the government or whether it's with another private sector party. And according to the lawyers I've talked to, that kind of has bred a willingness in these firms to, in their case, take an adversarial stance against the Trump administration. Now, that doesn't mean it doesn't come with any risk. There are risks involved. However, when you're litigating in a courthouse, as opposed to seeking merger clearance in an executive branch agency, the courthouses are not subject to the Trump administration's executive orders like the executive branch agencies are.
I didn't realize this. The litigation firms have less revenue than the transactional firms?
Yes, they're on average about half as much in revenue every year on average than the more transactional focused firms. And that really just goes to show you how much private equity and M&A has turbocharged the profits of the wealthiest firms right now. But I think what we're seeing right now is that it also shows you how precarious that wealth is.
That's why a lot of firms are caving before they're even targeted in an executive order.
There are several law firms that have come to the table with the Trump administration in order to negotiate their way out of an executive order. When you just look at the rationale, the pretext backing these executive orders, it's hard to imagine a high-profile law firm that Trump might not have a beef with. You know, everybody has some connection to a potential enemy of the president. And so that makes the potential targets of these executive orders pretty far and wide. And that, I think, is making a lot of law firms come to the table and try to negotiate preemptively their way out of an executive order.
Tell us about the sequence of firms settling with Trump.
It started with Paul Weiss, which was targeted in an executive order, and then they were able to get that executive order rescinded in exchange for the kind of deal that we would see three other firms adopt. Before issuing an executive order against them, the firms that proactively made deals with the Trump administration include Milbank, Wilkie, and Skadden. And these deals have all taken on very similar details. What differs is that Paul Weiss committed $40 million in pro bono services, and the other three firms committed $100 million each.
And then on Friday afternoon, 5 law firms reached agreements with the Trump administration worth hundreds of millions of dollars in free legal services.
5 of the biggest law firms in the world, 5 of the biggest and wealthiest law firms in the world, reached deals with the Trump White House to avoid punitive action against them in exchange for hundreds of millions of dollars in pro bono legal services. The deal that was announced on Friday says that Kirkland & Ellis, Latham & Watkins, Simpson Thacher & Bartlett, Cadwalader, and A&O Shearman are committing at least $600 million in pro bono legal services to causes advocated by Trump. That's a combined total of $600 million. There's slightly different numbers for each firm. Kirkland & Ellis, Latham & Watkins, Simpson Thacher, and A&O Shearman each are committing $125 million, while Cadwalader is committing $100 million. So the same as the deals reached by Skadden, Wilkie, and Milbank. Other parts of the deal are similar to what we've seen before. The firms are affirming their commitment to quote-unquote merit-based hiring, and the deal says that they will stay away from DEI-based hiring. This is a joint deal by these firms pledging pro bono services for the president.
So with this latest deal, that means the Trump administration is close to $1 billion in free legal services?
$940 million in pro bono services is my tally. So that aligns with what we heard from Stephen Miller at a Oval Office event earlier this week, where he said, you know, at the end of this, we're getting close to $1 billion in pro bono legal services.
And under these deals, what are the pro bono causes that the firms are going to litigate?
So just to make it totally clear, what the firms have said that have pledged pro bono legal services is that they aren't letting the Trump administration call the shots down to the individual client relationships. They've just set out categories that they need to provide pro bono legal services in order to comply with the agreement. And those categories include advocating on behalf of veterans' rights. You know, that's a very established conservative legal cause. There's combating anti-Semitism. And then there's, quote-unquote, fairness in the justice system. There's still a lot of unanswered questions about how they will comply with that. I struggle to imagine that the law firms and the Trump administration have the same definition of those things, especially with something as broad as fairness in the justice system. But these are clearly areas that, Trump for a while now has felt like big law isn't as fair to conservatives as it is to liberal causes. And so this is his way of, in his mind, evening the playing field.
And this week in the Oval Office, didn't he talk about new areas for pro bono work?
Yes, the president indicated that he's going to commit the law firms to work on behalf of coal mining efforts. I think he mentioned leasing, but that is, at this point, a vague category that there's still some details to be worked out. But I think the takeaway is that the president is starting to view these deals as like a pro bono piggy bank to commit to causes he supports.
Is this then the end of the executive orders targeting law firms?
I am honestly unsure if there's more firms that are going to be targeted. However, this does feel like a culmination event. This does seem to be what Trump had in mind when he said we are working with 4 or 5 more firms to come to a deal.
Let's turn for a moment to the firms that are litigating. So 3 firms have already sued the Trump administration, and they've gotten some temporary orders from judges.
Yes, so all 3 firms are looking for the executive orders against them to be totally halted, but what they've been able to get so far are temporary restraining orders against parts of the executive orders. I believe the parts that they were able to get temporary restraining orders for are the parts of the orders that ask agency heads to investigate any federal contractors that have relationships with these firms for possible termination. That is an issue being raised around, keeping client relationships a secret, which is a common practice in the world of lawyers. The other part that was halted was the one that pertains to access to federal buildings. The judges said that you can't bar the personnel of these firms from entering federal agency buildings.
And how has the Trump administration been defending these executive orders, which seem like retribution?
It does, but what people are calling retribution has been couched by the Trump administration in the language of protecting national security interests, the language that was used in the Perkins-Coie executive order. The other legal pretext that's being cited is anti-discrimination laws going after firms for alleged DEI, quote-unquote, discrimination.
Familiar themes of this administration. Thanks so much, Justin. That's Bloomberg Law reporter Justin Henry.
And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.